Hello and welcome to this Tolley Seminars Online lecture where I'm going to be looking at the application of the new public authority rules relating to IR35 in respect of how they will be applied in the NHS and the BBC. My name is Chris Jones. Let's first of all take a look at healthcare workers and firstly remind ourselves of the new rules which came in at the beginning of this tax year from the 6th of April 2017, where it is required that public authorities are now responsible for determining whether IR35 rules apply to what's known as off-payroll workers. In other words, workers that are engaged through public authorities that are not specifically paid through PAYE. Now, it's worth bearing in mind, of course, that the NHS uses a significant number of locums and agency staff in order to provide the services it requires to the public. And therefore, the following types of workers may well be affected by the application of these new rules. Firstly, and most importantly, those being paid through their own personal service company. At the moment, of course, it is down to the personal service company to determine whether IR35 applies and therefore whether PAYE must be applied or the PSC rules applied in regard to the way that that money is paid out of that company. And determining whether the individual indeed is deemed to be employed by that particular NHS organisation. But of course, going forward, the NHS, where they think IR35 will apply, will deduct PAYE at source. So that's the personal service company application, but the rules will also apply to those being paid through any umbrella company or organisation, and of course, those that are currently being paid gross as though they are self-employed, and where the NHS believes that that individual is in fact an employee, they will stop paying them gross and start applying PAYE, and that should be applied from the beginning of this tax year. So what does this mean in practice? Well, NHS Improvement is adopting the safest possible position, or that was how they saw things when these rules were first brought in. And therefore, the default was that all locum, agency and bank staff are going to be subject to PAYE, and there was a specific order to apply PAYE for all payments in respect of pay periods starting from the 1st of April 2017. Now, quite rightly, the British Medical Association disagree with this blanket adoption by NHS Improvement because, after all, the fundamental rules for assessing whether IR35 applies remain unchanged. In the fact, it is down to whether a deemed employment relationship exists between the worker and the NHS organisation impacted or making the payments. And therefore, to apply a blanket rule just to cover themselves seemed to be inappropriate, according to the BMA, a view that I concur with. So let's first of all look at what, for this purpose, is a public authority where the new IR35 deemed rules will apply. Well, the legislation defines a public authority as any authority defined by the Freedom of Information Act of 2000, and in respect of the NHS applies to the following: NHS England, clinical commissioning groups, or CCGs, strategic health authorities, local health boards, NHS trusts and foundation trusts, community health councils, general medical services practices, or GMS practices, and personal medical services practices, or PMS practices. Those not included are alternative provider medical services, or APMS providers. These providers often run the following types of services in the NHS: out-of-hours services, walk-in clinics, urgent care centres, alternative services where a GMS or PMS opts out of providing those services for themselves. And GMS and PMS practices can be APMS providers and will hold separate contracts in respect of these. And those types of contracts were introduced into the NHS from April 2013. So therefore, if your client is a medical practice or indeed a service provider covered by the APMS rules, then they will not be deemed to be a particular public authority, and as a result, those particular organisations will not be automatically required to apply the IR35 rules. Now, we are only a couple of months into these new rules, and you'll be pleased to know that it appears that the NHS has now made a U-turn in respect of this blanket adoption. Some of you may recall that earlier this year, 30 contractors abandoned an overrun £16.5 million IT project for the NHS when the NHS Trust told them that they would automatically be treated as being within IR35 from the 1st of April. And so these IT contractors, obviously being advised accordingly, basically said with down tools and said, well, if that's the case, you're not actually going to assess whether we are genuinely in business on our own account. We're not going to actually provide the services. And this was reported in the Register on the 31st of May. Now, as a result of this, the NHS has now said that they're going to treat individuals, quite rightly, on a case-by-case basis. Now, the big problem here is, as we all know, the NHS is struggling for resources. So how are they going to apply these rules as to assess every single worker that's being paid through some form of agency, assess whether they're employed or self-employed? This will be very difficult to organise. So the advice that I would give is that if you are acting for any contractors that are providing these services, they should put their case to the NHS Trust or organisation that they're working for, proving that they believe that they are genuine in business on their own account and therefore IR35 does not apply to them, and they should then be able to receive their payments gross. In other words, do that work for the NHS rather than rely on the NHS to do it for themselves, because as we've seen, the initial default position is that they will treat those individuals as though they are employed just for the sake of safety. But if your client can actually put forward their case, or you on their behalf, that they are genuine in business on their own account, they should continue to receive their payments without deduction of PAYE. Now let's move on and look at specific rules that apply to another public authority, the BBC. All contractors and freelancers, as well as the self-employed, will have their status assessed before being engaged to work for the BBC. So the BBC are adopting the appropriate approach and treating individuals based on their individual facts. But there is a bit more structure around this in respect of the BBC already, in that workers who satisfy the TV and radio modus operandi will be paid gross because they are deemed already to be on a list where HMRC confirmed that those roles on those lists and in the documentation provided by HMRC are not caught by the deemed employment rules and therefore not within IR35. Now, in principle, in order to be on this list and be satisfied by HMRC, an engagement must not exceed 9 months or on any specific programme, series, one-off production or film. But what happens if there is a re-engagement after the 9-month period? Well, the default position will be is that from that point, IR35 will be applied and therefore PAYE will apply to those payments, unless one of the following is met. The individual has had a genuine break and was seeking work elsewhere before they were re-engaged for a period that took them over that 9 months. Or they're being engaged on a second series of the same programme and that has been negotiated separately. In other words, it was not, they weren't engaged originally to do 2 series, but they did the first series and now they're doing the second series. Or the re-engagement does not exceed 9 months and was separately negotiated from the first engagement. Now, certain freelance roles require, in order to be on the modus operandi list, for a majority of the time to be spent away from BBC premises or BBC hired studios. In other words, treating them specifically as freelancers out in the field as opposed to working for the BBC in BBC premises. And certain roles require the freelance to buy, maintain and insure certain pieces of equipment that are required in order to provide those services, which is one of the hallmarks, as we all know, of being self-employed. There's also specific provision for what's known as special letters. If freelancers can provide sufficient evidence to HMRC that they are in business on their own account, then HMRC will issue them with what's known as a Lorimer letter or an LP10. And remember the case of Hall and Lorimer. This was the case that goes back a few years now, and back to 1993, where Mr. Lorimer had over 20 different assignments for the BBC and other recording studios, whereby HMRC said that he was employed for each separate engagement, but the courts held that Mr. Lorimer was in fact in business on his own account and took the risks as a self-employed individual. Now, the advice here to clients where they are freelancers for the BBC is that if the modus operandi rules do not apply, but your client you believe is genuinely running their own business, then apply to HMRC for an LP10, which do seem to be getting harder and harder to obtain, largely because we believe that HMRC are soon to roll out a new HMRC employment status tool, but we're not quite sure when that's going to arrive. But for now, do your absolute best you can to try and get an LP10 organised where you believe the modus operandi rules are not in point. But if the modus operandi rules are in point, then the BBC will be paying gross in any case. Well, I hope this is a helpful run-through of the application of the new public authority rules on IR35 in respect of the NHS and the BBC, and we will obviously keep you up to date on developments in this area through the Tolley Seminars online services. But for now, many thanks for listening. My name is Chris Jones, Chairman of Tolley.